Men must be governed by God or they will be ruled by tyrants. It's the duty of jurors, sheriffs, bailiffs, and justices to resist all infringements upon the rights of the people without delay. Whenever people are well informed, they can be trusted with their own government. Clearly, the government cannot be in charge of deciding for themselves whether or not they should indict themselves on criminal charges or not. This is precisely why we have so much corruption in our own government. It is the duty of the people to stand up as faithful and wise stewards and bring the servants who think themselves as masters back into subjection. The question each jurist must ask himself is there an injured party? There is a common law principle which states that for there to be a crime, there must first be a victim, corpus delicti. The state cannot be the injured party. In the absence of a victim, there can be no crime. This is what the grand jury must discover. The constitutions of most of our states assert that all power is inherent in the people, that they may exercise it by themselves in all cases to which they think themselves competent, as in electing their functionaries, executive and legislative, and deciding by a jury of themselves, both fact and law in all judiciary cases in which any fact is involved. Or they may ask by representatives, freely and equally chosen, that it is their right and duty to be at all times armed to freedom of person, freedom of religion, freedom of property, and freedom of the press. Thomas Jefferson, letter to John Cartwright, June 5th, 1824. The Thomas Jefferson Papers, Library of Congress. Grand jurors, 25 to be exact. It is the duty of the common law grand jury to expose all fraud and corruption, whether it is in the political or judicial realm, and stop it. The authority of the grand jury is found only in the Bill of Rights. Therefore, it comes from God and not government. Amendment 5. No person shall be held to answer for a capital crime or otherwise infamous crime unless on presentment or indictment of a grand jury. It is in effect a fourth branch of government, governed and administered to directly by and on behalf of the American people. Trial jurors, 12 of them. It is the duty of the jury to execute justice and sometimes mercy. Their decision cannot be second-guessed. The jury shall have the right to determine the law and the fact. New York Constitution, Article 1, subsection 8, as understood at common law and as used in constitutional provisions, jury imports a body of 12 men. State versus Dalton. Jury nullification. The jury has an unalienable right to judge both the law as well as the fact in controversies. John Jay, First Chief Justice, United States Supreme Court, 1789. The jury has the right to determine both the law and the facts. Samuel Chase, U.S. Supreme Court Justice, 1796. Signer of the unanimous declaration, signer of the unanimous declaration, the jury has the power to bring a verdict in the teeth of both law and fact. Oliver Wendell Holmes, U.S. Supreme Court Justice, 1902. Central to the history of the trial by jury is the right of jurors to vote not guilty if the law is unjust or unjustly applied. When jurors acquit a factually guilty defendant, we say that the jury nullified the law. The Founding Fathers believed that the juries in criminal trials had a role to play as the conscience of the community and relied on juries nullifying to hold the government to the principles of the Constitution. Trust in the jury is, after all, one of the cornerstones of our entire criminal jurisprudence, and if that trust is without foundation, we must re-examine a great deal more than just the nullification doctrine. Judge David L. Bazelon. There may be no feature more distinctive of the American legal culture than the criminal trial jury. Americans have a deep and stubborn devotion to the belief that the guilt or innocence of one person accused of a crime can only be judged fairly by a jury of his peers. This notion is a particularly American one, although it was inherited from English common law during the colonial era. Kentucky Resolution. A series of resolutions drawn up by Jefferson and adopted by the legislature of Kentucky in 1799, protesting against the alien and sedition laws, declaring their illegality, announcing the strict constructionist theory of the federal government, and declaring nullification to be the rightful remedy, justice. It is the duty of the justice to do justice. In common law, the title given in England to the judges of the King's Bench and the Common Pleas, which is important to note that in Pennsylvania, there still is a King's Bench here in the United States of America, all right? And the King's Bench is superior even to the Supreme Court. And in America, to the judges of the Supreme Court of the United States and of the appellate courts of many of the states, in the most extensive sense of the word, justice differs little from virtue, for it includes within itself the whole circle of virtue. Yet the common distinction between them is that which, considered positively and in itself, is called virtue, when considered relatively and with respect to others, has the name of justice, being in itself a part of virtue, is confined to things simply good or evil, and consist in a man's taking such a proportion of them as he ought. Bovier's Law Dictionary. The source of virtue is found in Luke 6:19 out of the King James Bible, and the whole multitude sought to touch him, for there went virtue out of him, and healed them all. Therefore, a justice is to reflect divine qualities, as we read in Philippians 4:8. Finally, brethren, whatsoever thing are true, whatsoever thing are honest, whatsoever things are just, whatsoever things are pure, whatsoever things are lovely, whatsoever things are good report, if there be any virtue, and if there be any praise, think on these things. That's where we look at equity. Sheriffs. America will never be destroyed from the outside if we falter and lose our freedom. It will be because we destroyed ourselves. The county sheriff is the last line of defense when it comes to upholding and defending the Constitution. The sheriff's duties and obligations go far beyond writing tickets, arresting criminals, and operating jails. The sheriff also has an obligation to protect the constitutional rights of the citizens in our counties. This includes the right to free speech, the right to assemble, and the right to bear arms. Remember the oath. Sheriffs took an oath to uphold and defend the Constitution from enemies foreign and domestic. In the history of our world, it is government tyranny that has violated the freedom granted to us by our Creator more than any other. And it is the duty of the sheriff to protect his county from those who would take away our freedoms, both foreign and domestic, whether it is a terrorist from Yemen or a bureaucrat from Washington, D.C. Bailiffs. Officers who perform the duties of sheriffs within liberty or privileged jurisdictions in which formerly the king's writ could not be executed by the sheriff. One to whom some authority, care, guardianship, or jurisdiction is delivered, committed, or entrusted. One who is deputized or appointed to take charge of another's affairs, an overseer or superintendent, a keeper, protector, or guardian, a steward, spellman, a sheriff's office or deputy. First Black Commentary 344, a court attendant. It is the duty of all the above to correct injustice in as much as it is in their power to do so. If correction is not possible, it is the duty of the court officer to report the problem to the protectors of the people, the grand jury, in whose hand justice has been entrusted. 1 U.S.C. Remedy of the people when rights are violated. U.S.C. Title 18, subsection 2382, misprision of treason. Whoever having knowledge of treason conceals and does not make known the same to some judge is guilty of treason for contempt against the sovereign, and shall be fined under this title or imprisoned not more than 7 years or both. U.S. Title 18 U.S.C. subsection 201, bribery. If any public official, directly or indirectly, gives, offers, or promises anything of value to any person to influence any official act, that would be a crime under Title 18 U.S.C. subsection 201. Title 18 U.S.C. subsection 241, conspiracy against rights. If 2 or more persons conspire to injure, oppress, threaten, or intimidate any person in any state in the free exercise or enjoyment of any right, they shall be fined under this title or imprisoned not more than 10 years or both. Title 18 U.S.C. subsection 242, deprivation of rights under color of law. Whoever under color of law, any law, statute, ordinance, regulation, or custom willfully subjects any person in any state to the deprivation of any rights shall be fined under this title or imprisoned not more than 1 year or both. U.S.C. Title 18, subsection 2071, concealment, etc. Whoever willfully and unlawfully conceals, removes, mutilates, obliterates, or destroys, or attempts to do so, documents filed or deposited with any clerk or officer of any court shall be fined or imprisoned not more than 3 years or both. Title 18, subsection 2076 of the United States Code. Clerk is to file. Whoever, being a clerk, willfully refuses or neglects to make or forward any report, certificate, statement, or document as required by law shall be fined under this title or imprisoned not more than 1 year or both. U.S.C. Title 42, subsection 1983, civil action for deprivation of rights. Every person who, under color of any statute, ordinance, regulation, custom, or usage of any state subjects, or causes to be subjected any person within the jurisdiction thereof to the deprivation of any rights, privileges, or immunities secured by the Constitution and laws shall be liable to the party injured in an action at law. Title 42, 1985 U.S.C. Conspiracy to interfere with civil rights. If 2 or more persons in any state or territory conspire for the purpose of depriving either directly or indirectly any person's rights, the party so injured or deprived may have an action for the recovery of damages against any one or more of the conspirators. Title 42, 1986 U.S.C. Action for neglect to prevent. Every person who, having knowledge that any of the wrongs conspired to be done or are about to be committed, and having power to prevent or aid in preventing the commission of the same, neglects or refuses so to do, if such wrongful act be committed, shall be liable to the party injured. 2. All is mine. Job 4:11. Whatsoever is under the whole heaven is mine. Ezekiel 18:4. Behold, all souls are mine. As the souls of the Father, so also the souls of the Son is mine. Exodus 19. Now therefore, if ye will obey my voice indeed, and keep my covenant, then ye shall be a peculiar treasure unto me above all people. For all the earth is mine. Psalms 50:12. If I were hungry, I would not tell thee, for the world is mine, and the fullness thereof. Proverbs 8:14. Counsel is mine, and sound wisdom. I am understanding, I have strength. 3. Government by consent. Our founders purposely placed the powers of the grand jury in the Bill of Rights to make it clear that it belongs to the people and the government is not to violate it. It is the ultimate power of the people which allows them to consent or not to take or not to the actions of their servant government. It also prevents government from unrighteous prosecution by forcing the government to seek permission from the people before criminal charges can be filed. If the people refuse, it cannot go forward. By understanding this principle, it becomes clear that the government has no authority to control your behavior, and therefore neither do legislators without your consent. The Declaration of Independence says, "We hold these truths to be self-evident, that all men are created equal, that they are endowed by their Creator with certain unalienable rights, that among these are life, liberty, and the pursuit of happiness, that to secure these rights, governments are instituted among men, deriving their just power from the consent of the governed. All men decide for themselves whether they want to participate in the institution of men or not. The United States Supreme Court confirmed this when they said, every man is independent of all laws except those prescribed by nature. He is not bound by any institutions formed by his fellow men without his consent." Cruden versus Neal, 2 North Carolina, 338, May term, 1796. 4. Only people can file a criminal complaint. There are only 3 ways a court can hear a criminal complaint. 1 or more of the people sign a sworn affidavit that they have been injured. 2, a prosecutor on behalf of the government brings an accusation before a grand jury, and the grand jury either indicts or does nothing. 3, the grand jury by its own will can investigate merely on suspicion that the law is being violated, or even because it wants assurance that it is not. And if it finds wrongdoing, it can present it to the court and it must go to trial. No one can second guess the grand jury unless the grand jury's actions violate another's unalienable rights. Principles of liberty. Consent and jurisdiction. It's all about consent and jurisdiction. In order to possess liberty, it is extremely important that you understand consent. Our servant government cannot do anything without your consent. Consent of authority. We read in the Declaration of Independence, we hold these truths to be self-evident, that all men are created equal, that they are endowed by their Creator with certain unalienable rights, that among these are life, liberty, and the pursuit of happiness, that to secure these rights, government are instituted among men amongst men, deriving their just powers from the consent of the governed. Any authority our servants have is by our consent. If they act outside their authority, they are subject to criminal charges under U.S. Code Title 42 and U.S. Code Title 18, and liable for damages under U.S. Code and common law. Consent to indict. The Fifth Amendment states, no person shall be held to answer for a capital or otherwise infamous crime unless on presentment or indictment of a grand jury. Therefore, our servant government requires the people to get an indictment grand jury. Judges, the servants, have no authority to make a ruling or a judgment on people, the masters, without your consent. In legal terms, when the judge asks you, do you understand, he means, do you stand under the authority of his court? So when you say yes, you give him, her, the court, jurisdiction over you. Only people can judge. Our U.S. Constitution only authorizes common law courts, aka courts of record. A court of record removes the power of the judge to make a ruling. His role is that of the administrator of the court. The final determination is the tribunal, who is either the sovereign plaintiff or a jury. Remember, the servant cannot rule over the master. Can the clay rule over the potter? Every man is independent of all laws except those prescribed by nature. He is not bound by any institution formed by his fellow man without his consent. Cruden versus Neal. Here's liberty. If you do not give a court consent, they have no jurisdiction over you. Under U.S. Code Title 42 and Title 18, when you are detained without your consent for violating a statute, you have just been kidnapped. And if the judge sets a bail, he just set a ransom. And when the prosecutor confirms the charges, he becomes part of the conspiracy, and you can put the conspirators in jail and sue them for damages. It's all about jurisdiction and consent. The common law is the real law, the supreme law of the land. The code, rules, regulations, policies, and statutes are not the laws. Self versus Ray, 61, Wisconsin 2D 261. Legislative statutes enforced upon the people in the name of law are a fraud. They have no authority and are without mercy. Justice without mercy is godless and therefore repugnant to our United States Constitution. Lawmakers were given authority by the people to legislate codes, rules, regulations, and statutes, which are policies, procedures, and law, to control the behavior of bureaucrats, elected and appointed officials, municipalities, and agencies, but were never given authority to control the behavior of the people. As we read in the U.S. Supreme Court decision, all codes, rules, and regulations are for government authorities only, not human creators, in accordance with God's laws. All codes, rules, and regulations are unconstitutional and lacking due process. Rodriguez versus Ray Donovan, U.S. Department of Labor, 769 F2D 1344, 1348, and the case happened in 1985. And again, all laws, rules, and practices which are repugnant to the Constitution are null and void. Marbury versus Madison. I'll remind you, Marbury versus Madison has never been overturned. 5th U.S. 2 Cranch, 137, 174, 176, and this case happened in 1803. Legislators simply do not have the authority to rule make. Where rights secured by the Constitution are involved, there can be no rulemaking or legislation which would abrogate them. Miranda versus Arizona, 384 U.S. 436 and 491. God breaks down the laws as follows, and Jesus answered him, "The first of all the commandments is, Hear, O Israel. Hear, O Israel, the Lord our God is one Lord, and thou shalt love the Lord thy God with all thy heart, and with all thy soul, and with all thy mind, and with all thy strength. This is the first commandment. And the second is like, namely this, thou shalt love thy neighbor as thyself. There is none other commandment greater than these." Mark 12:29 through 31. Although it is a sin punishable only by the judge of the universe to break the commandment to love in your mind, words, and deeds, it does not become a crime punishable by man until your words and deeds are expressed in actions that injure another. Thomas Jefferson said, "I would rather be exposed to the inconveniences attending too much liberty than those attending to small a degree of it. If one of the people exercises his free will to carry a weapon, travel, practice law, park without depositing money in a meter, use hemp, pharmaceuticals, alcohol, vitamins, minerals, or any other substances for medical or recreational purposes, the legislators do not have the authority to impose a fine, license, or make a right a crime." Number 6, Rights and sovereignty. Only people are sovereign and have rights. Bureaucrats in their capacity are not sovereign and have no rights. They have authority given by the people and are subject to the statutes. The state cannot diminish rights of the people. Hurtado versus People of the State of California, 110 U.S. 516. The assertion of federal rights, Bill of Rights, when plainly and reasonably made, is not to be defeated under the name of local practice. Davis versus Wetchesler, 263 U.S. 2224. Where rights secured by the Constitution are involved, there can be no rulemaking or legislation which would abrogate them. Miranda versus Arizona, 384 U.S. 436, 491. There can be no sanctions or penalty imposed upon one because of this exercise of constitutional rights. Sherrier versus Cullen, 481 F 946. Sovereignty itself is, of course, not subject to law, for it is the author and source of the law. Yik Wu versus Hopkins, 118 U.S. 356 370. Unregistered, undersigned is sovereign, and no court has challenged that status standing. To deprive the people of their sovereignty, it is first necessary to get the people to agree to submit to the authority of the entity they have created. That is done by getting them to claim they are citizens of that entity. See consent for the USA XIV amendment for the definition of citizen of the United States. Number 7, licensing liberty. No state shall convert a liberty into a license and charge a fee therefore. Murdoch versus Pennsylvania, 319 U.S. 105. If the state converts a right, liberty, into a privilege, the citizen can ignore the license and fee and engage in the right, liberty, with impunity. Shuttlesworth versus City of Birmingham, Alabama, 373 U.S. 262. Number 8, remedy for every injury. Williams Blackstone, a legal maximum. Every right, when withheld, must have a remedy, and every injury its proper redress. In the third volume of his commentaries, page 23, Blackstone states 2 cases in which a remedy is afforded by mere operation of law. In all other cases, he says, it is a general and indisputable rule that where there is a legal right, there is also a legal remedy by suit or action at law whenever that right is invaded. And afterward, page 109 of the same volume, he says, I am next to consider such injuries as are cognizable by the courts of common law, and herein I shall for the present only remark that all possible injuries whatsoever that did not fall within the exclusive cognizance of either the ecclesiastical, military, or maritime law or maritime tribunals are, for that very reason, within the cognizance of the common law courts of justice. For it is a settled and invariable principle in the laws of England that every right, when withheld, must have a remedy, and every injury its proper redress. 5 U.S. 137 Marbury versus Madison. The government of the United States has been emphatically termed a government of laws and not of men. It will certainly cease to deserve the high appellation if the laws furnish no remedy for the violation of a vested legal right. Marbury versus Madison, 5 U.S. 137, and that case happened in 1803. That statutes which would deprive a citizen of the right of person or property without a regular trial according to the course and usage of common law would not be the law of the land. Hawks versus Henderson, 15 North Carolina, 1525 AM, December 677. The right to be let alone is the most comprehensive of rights and the right most valued by civilized men. to protect that right, every unjustifiable intrusion by government upon the privacy of the individual, whatever the means employed, must be deemed a violation of the Fourth Amendment. Olmstead versus U.S. 277, U.S. 438, 478, 1928. Court. The court belongs to the sovereign plaintiff. People. Black's Law Dictionary, 5th edition, page 318, defines the court as the person and suit of the sovereign. The place where the sovereign sojourns with his regal retinue, wherever that may be. In the U.S. Supreme Court case, Isbell versus Stovall, the court is defined as an agency of the sovereign created by him directly or indirectly under his authority, consisting of one or more officers established and maintained for the purpose of hearing and determining issues of law and fact regarding legal rights and alleged violations thereof, and of applying the sanctions of the law authorized to exercise its powers in the course of law at time and place previously determined by lawful authority. Judicial notice. Judicial notice or knowledge upon which a judge is bound to act without having it proved in evidence. Black's Law, 4th edition. Take judicial notice of the American Jurisprudence, Book 16, Constitution Law, section which a judge is bound by oath to obey. Judges sworn to obey Constitution irrespective of opinion and consequences. Constitution rules over statutes. Since the Constitution is intended for the observance of the judiciary as well as other departments of the government, and the judges are sworn to support its provisions, the courts are not at liberty to overlook or disregard its commands or counteract evasion thereof. It is their duty in authorized proceedings to give full effect to the existing Constitution and to obey all constitutional provisions irrespective of their opinion as to the wisdom of or the desirability of such provisions and irrespective of the consequences. Thus, it is said that the courts should be in our altar to enforce the provisions of the United States Constitution and guard against their infringement by legislative fiat or otherwise in accordance with these basic principles. The rule is fixed that the duty in the proper case to declare a law unconstitutional cannot be declined and must be performed in accordance with the delivered judgment of the tribunal before which the validity of the enactment it is directly drawn into question. If the Constitution prescribes one rule and the statute another in a different rule, it is the duty of the courts to declare that the Constitution and not the statute governs in case before them for judgment. 16 Am. Jurisprudence 2D, Section 155, emphasis added. Supremacy Clause. This Constitution and the laws of the United States, which shall be made in pursuance thereof, and all treaties made, or which shall be made under the authority of the United States, shall be the supreme law of the land, and the judges in every state shall be bound thereby. Anything in the Constitution or laws of any state to the contrary notwithstanding. U.S. Constitution. Thus, the particular phraseology of the Constitution of the United States confirms and strengthens the principles supposed to be essential to all written constitutions, that a law repugnant to the Constitution is void, and that courts, as well as other departments, are bound by that instrument. After more than 200 years, this decision still stands. Marbury versus Madison, 5 U.S. 137, and this case happened in 1803. Common law is still the law of the land. All cases which have cited Marbury versus Madison to the Supreme Court have never been overturned. See Shefford's citation of Marbury versus Madison. The Constitution was ordained and established by people for the United States of America, aka the government. Therefore, government was created by an act of the people. Therefore, the created cannot trump the creator. If any statement within any law which is passed is unconstitutional, the whole law is unconstitutional. Marbury versus Madison, 5 U.S. 137, 1803. Therefore, no legislation, statutes which would deprive a citizen of the rights of person or property without a regular trial, according to the course of usage of common law, would not be the law of the land. Hooks versus Henderson. Or Hoke versus Henderson, 15 NC 1525 AMDEC 677. Where rights secured by the Constitution are involved, there can be no rulemaking or legislation which would abrogate them. Miranda versus Arizona, 384 U.S. 436 491. Interpretation in favor of the people. Any constitutional provision intended to confer a benefit should be liberally construed in favor of the clearly intended and expressly designated beneficiary. That a constitution should receive a literal interpretation in favor of the citizen is especially true with respect to those provisions which were designed to safeguard the liberty and security of the citizen in regard to person and property. 16 Am Jurisprudence 2D, 16 Am Jurisprudence 2D, Section 97, Berry versus United States, 273 U.S. 128. No emergency has just cause to suppress the Constitution. Well, an emergency cannot create power, and no emergency justifies the violation of any of the provisions of the United States Constitution or state constitutions. Public emergencies such as economic depression for especially liberal construction of constitutional power has been declared that because of national emergencies, it is the policy of the courts of times of national peril so liberally to construe the special powers vested in the chief executive as to sustain the effectuate the purpose thereof, and to that end also more liberally to construe the constituted divisions and classifications of the powers of the coordinated branches of the government, and insofar as may not be clearly inconsistent with the Constitution. 16 Am Jurisprudence 2D, Section 98. Constitutions must be construed to reference the common law. Summary proceedings are null and void. As to the construction with reference to the common law, an important canon of construction is that constitutions must be construed to refer to the common law. The common law so permitted destruction of the abatement of nuisances by summary proceedings, and it was never supposed that a constitutional provision was intended to interfere with this established principle. And although there is no common law of the United States in a sense of a national commentary law, as distinguished from the common law of England adopted in the several states, in interpreting the federal constitution, recourse may still be had to the aid of the common law of England. It has been said that without reference to the common law, the language of the federal constitution could not be understood. 16 Am Jurisprudence 2D, Section 114. Shall not infringe. Various facts of circumstances extrinsic to the Constitution are often restored to by the courts to aid them in determining its meanings. As previously noted, however, such extrinsic aids may not be restored to where the provision in the question is clearly and unambiguous. In such a case, the court must apply the term of the Constitution as written, and they are not at liberty to search for meanings beyond the instrument. 16 Am Jurisprudence, Section 117. I'm getting eaten alive by the bugs out here. And I need to get me a little bit of a Drink here. Are you serious right now? Man is mankind. Woman was taken out of man. Can't you take a good ribbing? Yep. All right. Irreconcilable conflict between statutes and constitution is to be resolved in favor of constitutionality and beneficiary. In all instances where the court exercises its powers to invalidate legislation on constitutional grounds, a conflict of the statute, which the Constitution must be irreconcilable. I can't say it now. Irreconcilable. Thus, a statute is not to be declared unconstitutional unless so inconsistent with the Constitution that it cannot be enforced without a violation thereof. A clearly incompatibility between law and the Constitution must exist before the judiciary is justified holding the law unconstitutional. This principle is in line with the rule that doubts that the constitutionality should be resolved in favor of the constitutionality and the beneficiary. Now, something to point out here, they keep referencing beneficiary. Beneficiary, ladies and gentlemen, is a trust term, okay? Because the Constitution is in fact a trust, and it can be proven by just reading the preamble of the Constitution. If you read the preamble of the Constitution here, let me just find it, my handy dandy little pocketbook here. We, the people of the United States, in order to form a more perfect union, establish justice, ensure domestic tranquility, provide for the common defense, promote the general welfare, and secure the blessings of liberty to ourselves and our posterity, do ordain and establish this Constitution for the United States of America. Ladies and gentlemen, that is we, the people, that is us, that is our. When you say I, you're acting in an individual capacity. An individual is, in fact, a corporation, joint partnership, venture. So when you understand or comprehend and your heart starts to open up to what I just read you, the preamble shows you the intent of the grantor, the testators, showing you that you could be part of this compact if you wish to be. And this compact doesn't bind you, but rather binds your servants. So you get to decide whether you're going to be a U.S. citizen or whether you're going to be an American man or woman. That choice is really yours. You can accept and acknowledge it for what it is, or you can dismiss what I'm saying after studying trust law for a long time and just be like, this guy's nuts. That Constitution doesn't apply to me. I wasn't a signer to the contract. I wasn't a party to it. Well, you don't want to be a party to it. I don't want to hear you crying anymore about cops beating you, tasing you, and sticking you in cages. Because I just gave you a huge answer to what needs to be done. You need to accept and acknowledge the Constitution for what it is. So, with that said, I'll continue on. Supreme law is the base of all law. All fiction of law is null and void. Nisi prius, all right? Courts rely on statutes, which is fiction of law that seeks to control the behavior of the sovereign people of New York and other states, who are under common law, not statutes, and who ordained and established the law. Therefore, legislators cannot legislate the behavior of the people. No provisions of the Constitution is designed to be without effect. Anything that is in conflict is null and void of law. Clearly, for a secondary law to come in conflict with the supreme law is illogical, for certainly the supreme law would prevail over all other laws, and certainly our forefathers had intended that the supreme law would be the basis of all law, and for any law to come into conflict would be null and void of law. It would bear no power to enforce. It would bear no obligation to obey. It would purport to settle as if it had never existed. For unconstitutionality would date from the enactment of such law, not from the date branded in an open court of law, no courts are bound to uphold it, and no citizens are bound to obey it. It operates as near nullity or a fiction of law. All codes, rules, and regulations are for government authorities only, not human creators, in accordance with God's laws. All codes, rules, and regulations are unconstitutional and lacking due process. Rodriguez versus Ray Donovan. The common law is the real law, the supreme law of the land. The code, rules, regulations, policies, and statutes are not the law. Self versus Ray. RHAY 61 WN 2D 261. No one is bound to obey an unconstitutional law, and no courts are bound to enforce it. The general rule is that an unconstitutional statute, whether federal or state, though having the form and name of law, is in reality no law, but is wholly void and ineffective for any purpose, since unconstitutionality dates from the enactment and not merely from the date of the decision so branding it. An unconstitutional law in legal contemplation is as inoperative as if it had never been passed. Such a statute lives as questions that it purports to settle, just as it would be had the statute not ever been enacted. No repeal of an enactment is necessary, since an unconstitutional law is void. The general principle follows that it imposes no duty, conveys no right, creates no office, bestows no power of authority on anyone, affords no protection, and justifies no acts performed under it. A contract which A contract which rests on an unconstitutional statute creates no obligation to be impaired by subsequent legislation. No one is bound to obey an unconstitutional law. No courts are bound to enforce it. Persons convicted and fined under a statute subsequently held unconstitutional may recover the fines paid. A void act cannot be legally inconsistent with a valid one, and an unconstitutional law cannot operate to supersede an existing valid law. Indeed, insofar as a statute runs counter to the fundamental law of the land, it is superseded thereby, since an unconstitutional statute cannot repeal or in any way affect an existing one. If a repealing statute is unconstitutional, that statute which it attempts to repeal remains in full force and effect, and where a statute in which it attempts to repeal remains in full force and effect, and where a clause repealing a prior law is inserted in an act, which act is unconstitutional and void, the provision of the repeal of the prior law will usually fall with it, and will not be permitted to operate as repealing such prior law. The general principle stated above applied to the Constitution as well as the laws of the several states, insofar as they are repugnant to the Constitution and the laws of the United States. 16 Am. Jurisprudence 2D, Section 256. Congress cannot alter rights. On the other hand, it is clear that Congress cannot authorize or ratification give the slightest effect to a state law or constitution which is in conflict with the Constitution of the United States. 16 Am. Jurisprudence 2D, Section 258. Rights do not come in degrees. Although it is manifested that an unconstitutional provision in the statute is not cured because it included in the same act with valid provisions, and that there are no degrees of constitutionality. 16 Am. Jurisprudence 2D, Section 260. States cannot license rights. A state may not impose a charge for the enjoyment of a right granted by the federal Constitution, and that a flat license tax here involves restraint in advance of the constitutional liberties of press and religion, and inevitably tends to suppress their existence. That the ordinance is non-discriminatory, and that it applies also to peddlers of wares and merchandise, is immaterial. The liberties granted by the First Amendment are in a preferred position, since the privilege in question is guaranteed by the federal Constitution and exists independently of the state authority. The inquiry as to whether the state has given something for which it cannot ask a return is irrelevant. No state may convert any secured liberty into a privilege and issue a license and a fee for it. Muddock versus Penn, 319 U.S. 105. In this case, happened in 1943. If the state does convert your right into a privilege and issue a license and a fee for it, you can ignore the license and a fee and engage the right with impunity. Shuttlesworth versus Birmingham, AI 373 U.S. 262, 1962. Officers of the court have no immunity for liability when violating constitutional rights. The right of action created by statute relating to deprivation under color of law of a right secured by the Constitution and the laws of the United States, and some claims which are based solely on statutory violations of the federal law and applied to the claim that claimants had been deprived of their rights in some capacity to which they were entitled. Owen versus Independence, 100 volume Supreme Court Reports, 1398, 1982. Maine versus Tibbott, 100 volume Supreme Court Reports, 2502. 1982. Title 18 U.S. Code subsection 241 and section 242. If upon conviction you are subject to a $10,000 fine, 10 years in jail, or both, and if theft results, life in prison. Title 42 U.S. Code section 1983, section 1985, and section 1986 clearly establishes the right to sue anyone who violates your constitutional rights. The Constitution guarantees he who would unlawfully jeopardize your property loses property to you, and that's what justice is all about. Judges are deemed to know the law and are sworn to uphold it, and can hardly claim that they acted in good faith for willful deformation of a law, and certainly cannot plead ignorance of the law, for that would make the law look unintelligent. For a knowledgeable judge to claim ignorance of the law when a citizen on the streets cannot claim ignorance of the law, therefore there is no judicial immunity. And with that, ladies and gentlemen, I'm going to say good night to you guys, and thanks for joining me. But I thought it was important to get this information out to you. Thanks again for joining me, and we'll talk to you tomorrow.